Welcome to our final session of today, our closing plenary with Professors Rosemary Auchmuty and Erika Rackley. I will keep my introduction brief because I know we'd all much rather hear from them. Rosemary is Professor of Law at Reading University. She has many publications in many areas of law, including early women lawyers. Erika Rackley is Professor of Law at Kent University. Her research extends again over many areas, including judicial diversity, feminist legal history, and the Feminist Judgments Project. And Rosemary and Erika co-led the wonderful Women's Legal Landmarks Project. Women's Legal Landmarks involved workshops, a website, and a fantastic book. Several of us here and many other people were participants in it, and they're going to talk today about lessons from the Women's Legal Landmarks Project, the interwar years.
Well, thank you. It's wonderful it's been a great day. Lovely to hear everyone working in the field. So yeah, I'm going to talk first, and then Erika is going to finish up. And one of the reasons why we don't have any slides, and you have to look at our faces, well, one is that we thought it would make a more relaxed end to the day. But the other is that I particularly wanted to see what was going on, and try and, if you like, to craft what I'm going to say slightly to the themes that have emerged, because one of the problems I have with these sorts of symposia is that you don't actually know who you're talking to. You may be talking to people who know more than we do about this, who are very far advanced in thinking about writing feminist legal history and feminist legal biography, but you may be talking to people who are just beginning to do that. And so on the one hand, I don't want to say what everyone knows and has heard before, but on the other hand, we didn't want to be talking above people's heads. So not stating the obvious, but then not leaving out the obvious either. And I think the audience is quite a mixed one, from the judging really from the presentations we've had, that there are some people who are just starting out, and we've got some people who really know what they're doing. So the first thing then that I want to say, the first lesson that we learnt from doing the project that Caroline described, which involved 100 people roughly, from all sorts of different disciplines. Some were not academics. We had judges and lawyers, and we had retired people, independent scholars, and so on. They were all contributing to the project, which was intended to commemorate the centenary of women's admission to the legal profession, but actually looked at women's legal history as far back as we wanted to go. And it was, in fact, the very earliest landmark was by one of the presenters today, Carol Howells, which was great because that was from the 10th century. And what was lovely was people weren't allocated, they chose what they wanted to write. And as Caroline said, we had lots of workshops where we listened to each other and commented, and we read each other's work and so on. And we have this fabulous book here. I just want to show it. Fabulous book. There we are, which is in paperback too, but it is enormous, and the website. And we would have done 100 other things if there hadn't been for COVID, but anyway. We still are interested in the project. We're still looking ahead, as indeed everyone is. So the first lesson we learned, I think, was the joy and the profit that you get from collaborating. Truly, if you put together all those people, it's not just so fabulous to be working with and to meet, to talk to get to know people from all over who are working in this field, who have the same passions as you do, but the amount of knowledge and experience and the skills that you put together far exceed anything that you could do on your own or with just a few people. I mean, obviously collaborating with Erika was a huge joy. That was great. That was fantastic. She's marvelous, for me at least, to work with. But all these other people then were putting in their bit, their knowledge, their understanding, sharing that in these workshops and by reading other people's work and so on. And so we ended up, I think, with something that was really authoritative, really, really well researched. And as a result of that, and of course, then we got to know all these people, so we can go on working with them and they can go on spreading the word and so on in their own institutions or wherever they are. One of the things we learned, though, was that people coming with different skills often lacked some skills, and that's particularly true of many legal scholars who aren't familiar with other disciplines, who perhaps their legal training has not included any training in history or in historical method, in those sorts of things, in doing research outside of legal sources. So we did try and address that with some workshops on archives and working with secondary sources. And we also, of course, shared our own knowledge and experience with each other. And as a result of that, we put together a template which we've used in the book, and which I think is a really fabulous guide for how to set out work in a landmark, which included the things which many people have talked about today, the context, not just looking at what happened, but what was the social and legal context in which it happened. And also, of course, something else that people have mentioned, we looked at what happened next, because there is a tendency in the way that history is passed down, and particularly legal history and the way we're taught, to think of the achievement of the reform, whatever it was, as the end of the story. Everything's fine from then on. So if you then include what happened next, you can see that what happens next almost always is a backlash against women's advances. There's a strong movement to curtail the reform, to interpret the law in perhaps a narrow way, something like that, which means that in the end, and of course often the reform isn't what we'd asked for anyway, it was a compromise itself. So that was important to look at what happened next. And as a result of what we'd done, Erika and I got together and wrote 2 articles, one on feminist legal history, which sets out both the justification for feminist legal history and a methodology. And we, of course, thought, oh, this is the last word on the subject, but it's very clear it isn't. That already people are beginning to add insights to problematize some of the things that we've said. And that's good. I mean, that shows that it's a developing discipline. And the other piece, that was in the Oxford Journal of Legal Studies, and the other piece was on feminist legal biography, which was in the Journal of Legal History. And that looked again at why we need feminist legal biography, and not just of women. We need to apply feminist methods to biographies of legal men too. And it set out a sort of a series of, these are things you should do and these are things you shouldn't do. And many of you here will know how Erika and I feel about setting up heroines as indiscriminate role models for us all, and the perils and pitfalls of getting too close to your subject, which is what Judith addressed, and Judith was, of course, part of the project, and many other things. So, you know, I recommend those to you, but we learned other things as well. It isn't the end of the story. And one of the things that we learned was, I suppose, okay, we knew that lots of women's legal history had been forgotten. We knew that. That's why we did the project. I think we knew how it had been forgotten, how it had been suppressed, largely in, I think, the ways in which legal history has been written, history generally has been written, and certainly the ways in which law is taught in the universities. It certainly the kind of education we had. I hope it's different now with all of us teaching in our various institutions, but it was taught without much reference to women except as victims and beneficiaries of men's wonderful reforms on their behalf. I think we understood why women's history has been forgotten and suppressed, because obviously any society that's dominated by a particular group likes to keep power, And if there are advances for another group, then it's losing power. And it's always trying to return to the status quo. And you want to keep quiet about what women have done and campaigned for so that the next generation of women doesn't think they can do the same. It's a very good way of buying off further complaints. One thing, though, that I don't think I had predicted, and which I've now come to understand about the way in which our history is lost, is that it takes so long for so many reforms to come into fruition. I mean, things like the vote, for example, took 70 years from the first real feminist campaign for it. And things like equal pay, about 150 years. There were campaigns for years and years and years. And it's huge, not just decades, but whole generations. And by the time they come along, they seem kind of, well, of course, you know, they're not so surprising anymore. They're almost inevitable. And what that means is, for that generation of women, and people generally, they don't appreciate always just how hard it's been to get that right, because our history gets lost. And indeed, the next generation of feminists gets quite critical of the one before. Why on earth didn't they do it this way? Why did they take so long? Why did they get it wrong? Well, they can't have understood, and so on, with no sense of the obstacles in their way. And I do think that that's very important in writing biography, that, you know, you don't set these people up in terms of all their great achievements. You actually look at just what they went through to get there, and you look at what happened next. Because very often you'll get one person there and that's it. Ah, well, we've got a woman judge, you know, we don't need any more. So that was interesting, I think. And this leads me on then to the interwar years, because one of the lessons we learnt when we published our book was that there's a very uneven spread of landmarks across the years. As you would expect, the vast majority come from the last 50 years. And this is partly because most of the people who are contributing would be familiar with current law, and that's mostly what's happened in the last 50 years, and so they wrote about that. It's also, of course, because from the 70s onwards, we've had a fairly steady feminist movement pushing for reform, and we've also had the influence of the European Union and other equality projects. So the vast majority, more than half, were from the last 50 years. And there was quite a sprinkling from the first wave of feminism in the 19th century. But what was interesting was, even though women got the vote, some in 1918, and were admitted to the legal profession in 1919, and even though the biggest argument for votes for women was, then we'll be able to have an influence on MPs so that they will have to consider women and take up women's issues because there are now women voters. They'll have to please their female electorate. Even though that was the case, we've actually got very few interwar landmarks in the book. We've got several firsts in the 20s, and of course we've talked about that today. Several first, you know, the first woman barrister, the first woman solicitor, the first women magistrates, and so on. We've got them. And we've got one or two other reforms from the 20s. We haven't got a single landmark from the 1930s. Now, we weren't trying to be comprehensive. You have to understand that people volunteered their own landmarks. But I think it's indicative of the fact there isn't much knowledge of this period, and therefore nothing obvious that anyone chose that was in that decade, even though that was the decade when all women had the vote on the same terms as men. So we have to ask ourselves why this is the case. Obviously, as I said before, whenever you have a big reform like votes for women or women in the professions, you'll have a backlash. And there was an awful lot of backlash going on. But I think there are other issues too. I mean, the trouble is, looking back, we think, well, either it was all backlash or there can't have been any feminist movement. And for a long time, it was thought there were no feminists in the interwar years, that once they got the vote, feminists just disappeared. And many years ago, about 30, 40 years ago, Dale Spender, an Australian scholar, wrote a wonderful book called There's Always Been a Women's Movement This Century. And she interviewed 5 women, now all long dead, of course, but who had been involved in the interwar period. So, of course, there was feminism. There were women MPs who were bringing private members' bills on all sorts of issues that were designed to benefit women. And guess what? They didn't get passed. And that then led Erika and me to think about doing something on the interwar years, doing another Women's Legal Landmarks project. And the publisher was very keen for us to do something else. Nothing big, not a major blockbuster of the sort that the first one was, which was like it was the first, but a slim volume of additional landmarks from the interwar years. And of course, we talked to various people who we knew had written in the field, and they were all very keen. But the more we thought, we found about 20 landmarks, I think, that we could write about. So we could have had a slim volume. But the more we thought about it, the more we discovered that there were all these landmarks that didn't come about, that weren't achieved, or were achieved afterwards. So, for example, the Family Allowances Act was 45, I think, after the war. The Nationality Act, which I think was mentioned in the context of Crystal Macmillan, that didn't come till 1948. But both of those were campaigns which began in the 20s, if not before, actually. So we realized that the reason why there weren't all that many landmarks in our book was not that there wasn't any feminism, but that it wasn't being successful. And we thought it was not for want of trying. The feminists tried. And of course, that's what we're going to call the book, Not for Want of Trying, which I think is really great. And what's going to make it different, we hope, is that this is not just going to be the successful landmarks. It's actually going to include some of the others. And we've talked a little bit about methodological difficulties in doing women's research on women's legal history. And we know how hard it is to get information. Well, I can tell you, I think the challenge of getting information on something that didn't get through is actually going to be much greater. But you know something? If, as we think, feminism is a political movement, a political act, not just a methodology, then if we are going to look at history partly for the lessons it teaches us for feminism and feminist activism, then it's often the unsuccessful things, the routes not taken or things not achieved in quite the form that we wanted. They're often perhaps the best things for us to look at in terms of determining our future strategy. So now I'm going to pass over to Erika, and you can conclude.
Hi. So I have to just start by offering my I've been spotlighted. My thanks for having me, for this being a wonderful event, and I've had to dip in and out. So one possibility when you speak at the end of the day is that you spend most of the day putting red lines through what it was you were going to say, because other people say them far more eloquently than you, which is always also the case when you follow Rosemary. Or you spend the day marveling at the impressive thinking of everyone else, and so by the time you get to what you've got to say, you're convinced that you've got nothing really to add, otherwise somebody else would have said it. And so the way in which I've sought to try and avoid this is to look at the topic and the title that we chose, and to take a kind of deliberately sideways look at it, and to explicitly identify your contribution as a thought or a postscript. Or when I described what I was going to say to Rosemary, she described it as a homily, which I thought was really lovely until I looked it up and just discovered it was a tedious moralizing lecture. So don't say you haven't been warned. But anyway, the other way is to try and embrace some of the threads and to bring together some of the key themes, which is how which is what Rosemary's doing before me, on the basis that all good ideas bear repeating. So my plan is to do a bit of all these things and to say something about the motivations of both this seminar today and the various women's legal landmarks projects and other things, which is about centenaries. So centenaries are by and large good things. They're times for celebration, for reflection, for telegrams from the Queen. They provide a hook or a reason or a waymark, or what Caroline described earlier on as an anchor for looking at certain things. And of course, this year, as well as the centenary of Olive Clapham, we've also seen the centenary of Chanel No. 5. And actually, for the weather that we're having at the moment, the arrival of automatic windscreens wipers in the UK. Other notable anniversaries include the 700th anniversary of Dante's Divine Comedy. It's been 50 years since the debut of Led Zeppelin's Their Way to Heaven, and 75 years since the Christmas classic It's a Wonderful Life. And also 151 years since the death of Charles Dickens, novelist, legal critic, and creators of many wonderful characters, which incidentally is one of the first things I wanted to say that we need to watch out for when thinking about centenaries and other notable anniversaries, which is the need for round numbers. Anyway, Charles Dickens and his wonderful characters leads me to Mrs. Jellyby. Now, as some of you may remember, Mrs. Jellyby inhabits Dickens's London in the early pages of Bleak House. Oblivious to the needs of her many children, one of whom we're told has its rather large head firmly lodged in some railings, she practices what, and oh my goodness, Laura, I felt your pain as you were talking earlier on, and I'm now going to do it again, so I'm with you. She practices what Dickens describes as telescopic philanthropy. I was practicing that in the shower this morning, a burning, all-consuming passion to do good at a great distance. And of course, leaving aside Charles Dickens and Mrs. Jellyby's deeply problematic politics, Dickens' point is, of course, that charity should begin at home, and that people devoted to distance or telescopic philanthropy often show a tendency to neglect the needs of those around them. Now, I'm not suggesting that legal historians, and let alone those of the feminist ilk, are unaware or unconcerned of what's going around them. Far from it, and we've seen examples of that today. But what I did want to say was something around telescopic legal history, the act of looking back to key legal dates and anniversaries, and anniversaries, and the related condition of first or single woman itis, as well as saying a bit about why feminist legal historians, a group that I'm really grateful to occasionally be allowed to hang out with, notwithstanding my absence of historical training, is a vital political endeavour. You see, the trouble with centenaries is that amidst the celebration, the victories and the success of one or even a number of women, is that the danger is that the centenary is treated as the end rather than the beginning, as fixed rather than contingent, a marker in a Whiggish history of inevitable progress, albeit one accompanied by a caveat that it's perhaps not as fast as we might like. So not so with feminist legal history, for whom the what happened next is as important as the what happened then. And that was why it was so important that within our discussions today, we had Leona Samuta's paper about the backward steps precipitated by the ongoing pandemic. Although, let's not kid ourselves that it was all fine before this. We know that, like many crises, the pandemic has simply heightened and made visible trends and cracks in a failing system propped up by unrealistic expectations, by patriarchy and by fear. A further trouble, which has been identified today, is that with centenaries we celebrate the ones who made it, the successes and the winners. We rarely celebrate the women who were second to do something. Of all her plaudits, Lady Hale, for example, is rarely lauded as the second woman on the Court of Appeal. Maybe it's because she had so many firsts that it would seem churlish to point out that somebody got there before her. Or maybe if she hadn't had all those firsts, we wouldn't know that she was the second. As an aside, searching for a non-legal example here, I Googled second woman on the moon, only to discover, much to my shame of my ignorance and the reality, that 52 years after Neil Armstrong walked on the moon, a woman is yet to do so. Though NASA said in 2020 that it had plans for this to happen in 2024. This brings me to my next point. Most centenaries are about things that happened, or something that stopped happening, or was prevented from happening. And again, feminist legal history is on the march here, as Rosemary was talking about, to identify the not quites, the almosts, and the if onlys, the landmarks or events that, not for the want of trying, didn't come to pass. The centenary of the first visible minority to be appointed to the senior judiciary will not be for another 83 years. I won't see it. Hopefully my 5-year-olds will, but even they are unlikely to see the centenary of the first woman of colour to be appointed to our higher court. Finally, as I noted at the beginning, the worst in centenaries encourage us to search for round numbers, to distort our focus and to encourage us to overlook people and events falling outside our time frame. At best, however, centenaries are catalysts for change. They restart and they amplify conversations about women's participation in political institutions, about the progress of women lawyers, about access to justice, to money, to healthcare. And it is our responsibility, as we are demonstrating here today, not only to continue these conversations, but to improve and to expand on them, to celebrate our histories on their own terms, but also to instrumentalise them, just like Caroline is doing here, just like Eduardo Rees is doing in his regular seeking out of features on women's legal landmarks for the Law Society Gazette, as we are hoping to do with our Interwars landmark collection, and as many others are continuing to do, because feminist legal history teaches us to focus on those who came before, alongside and after the centenary, and not to fetishise the achievements of individuals over the reality of the collective, or in the rush to make visible, to silence the yet unheard. As we've heard a number of times today, it's not to isolate the individual from her context or community, or worse, our particular hobby horse, to reinforce or legitimate myths and inaccuracies. We need to reject telescopic histories of women in law and elsewhere, where stories of women are collected as if one might trade football cards. It requires us to utilise our history in the battle of today and to be the best, both the best and the worst of Mrs. Jellyby. You see, centenaries provide us with a hook, an excuse, a waymarker, a stepping stone. They allow us to say something about the past and to locate it and to make it visible. They provide us with an opportunity. Oh, this really is quite like a homily now, but I'm almost at the end. I realise as I'm saying this, I relate too much at the feet of my father. To draw connections between the past and the present, and to identify progress and failure, to provide better and richer explanations for where we've been and more profitable pathways as to where we may go next, to apply pressure or to keep pressure on and to make arguments for change, and to carve out space for women today who were denied space and visibility and a voice yesterday. And most of all, that's there for us to celebrate and, importantly, to say thank you. And that's where I'll finish today.